We're in the information age, but facts are in short supply. Reject the noise, ask bold questions, and pursue the truth with FBI whistleblowers and founding suspendables Garrett O'Boyle and Steve Friend. This is the American Radicals Podcast.
It is the American Radicals Podcast on a Thursday, and it's a very special Thursday. We're going to have a guest today. We haven't had one in a while. I actually looked back through the archives, and it's been since June. Garrett and I are each other's guests. Normally, that's how we like to do things. And we're appreciating how you're joining us today on Rumble. Rumble.com/AmRadPod is where you always find us on Tuesday, Thursday, Saturday, 10:30 Eastern time. Be sure that you smash the thumbs up, follow the channel, subscribe if your heart compels you to do that, and make sure you subscribe to the audio format of the podcast on iTunes, Spotify, iHeart, so that you can get the automatic updates when we drop them, and give us a 5-star rating so we can trick big tech into sharing the show with a greater overall audience. I don't want to belabor it very long, but just a brief intro on our guest today, Mr. Jonathan Gross. He is a defense attorney. He's a defense attorney for a lot of the January 6th defendants. And Garrett and I bring a perspective of the law side of the law and order. He brings the order side of things. And hopefully we're going to have a conversation that's going to fill in some gaps. He is a guy who I was really impressed by. He did a recent interview on Daniel Horowitz's podcast, Conservative Review. He seems to be a total bro. He is the suspendable type of guy. He's doing the right thing at the right time and the right way for the right reasons. And we want to make sure we give him as big a platform as we can so he can share the stories about how the due process is not being followed as we're coming in on a new presidential administration. The possibility of pardons is out there, but at the same time, we can't forget how the prime directive of following the process was something that was lost in the shuffle. It became an outcome-driven operation, which is completely out of step with the way that you expect your government to represent you. So without further ado, Garrett, get on here, and we'll bring on Jonathan because I think that he's got an interesting voice and an interesting perspective, and we want to make sure we share it with the American Radicals Podcast audience. Jonathan, thank you very much for joining us today. I really appreciate your time on this. And just for the benefit of our audience, can you just give an intro of who you are and actually how you got into the legal profession so that we have your bona fides established?
Sure. Yeah. My name is Jonathan Gross, and I'm a civil rights attorney in Baltimore, Maryland. But I was not always an attorney. I was a congregational rabbi for about 15 years. And at a certain point, I decided I wanted to do something else. I went back to law school. And then I graduated in 2019. And I was working in just general civil rights litigation. And then around the end of 2022 rather, I just was following the January 6th proceedings, and I was really just outraged by what I was seeing. So at the encouragement of my wife, I quit my job, started my own practice. Somehow, just through the hand of God, got involved with a couple of January 6ers, and now it's 2 years later, and I've been involved with many, many others since then, and that's where I am.
Was your first exposure to trial law for the January 6th, or did you at least have your feet wet that you could have come in with a certain level of subject matter expertise?
Yeah, right. So my background, when I graduated law school, I first clerked for a trial court judge, and I wanted to do civil litigation. So I witnessed a lot of criminal trials, but I was really focused more on doing civil. Then I worked for a general civil litigation firm for a little bit, and then I had an opportunity to go to a civil rights litigation. So just for your audience, the difference is civil litigation is just a contract dispute between two companies, or maybe a tort lawsuit, like a malpractice or something of that nature, professional malpractice, which I did a lot of on the defense side. And then I went into civil rights, which is different than general civil litigation. That's where the government comes in and takes away your constitutional right somehow, either by, let's say, violating your First Amendment, by preventing you from being able to speak the way you want, assemble the way you want, pray the way you want, or by violating your Fourth Amendment right, by searching and seizing you in a way that is not permitted by the Constitution. So that's civil rights. So that's not criminal law. I would be the plaintiff side in that case, and we would sue the government. I still do that. And we sue the government against abridgment of constitutional rights. So that's really what I wanted to do. And that's currently what I do. And then when I saw the January 6th stuff, well, that's criminal law.
I think we're having some connection issues here with Jonathan. Here, are you back?
Got me back?
Yep.
I think I'm back. Yeah.
Yeah,
so as I was saying, I was doing civil rights litigation, and now I do that still, but for January 6th, that's the only exception where I do criminal law, where the government's coming after them and I defend them. I'm a criminal defense attorney for them.
I want to jump in here for a second because I think we have found a kindred spirit here, Steve, but just with a different approach. So one thing, Jonathan, Steve, and I often talk about is our love of civil rights and how that was a driving factor for how we both ended up in law enforcement. And I just want to ask, where's your passion in civil rights rooted? Because I know for Steve and I, it's similar in that it's highly important to protect people's rights as far as our Constitution goes, not just from a legal standpoint, but from a moral standpoint, and for both of us from a biblical standpoint. But you got into the legal profession, the lawyer side of things, where both of us went into law enforcement. So I'm sure there's a little bit of difference there. But we often joke that we are more like ACLU attorneys from the 90s than cops from the mid 2000s.
Yeah, and I almost wish that the ACLU was still practicing civil rights, because they're not. They're not interested anymore. They're basically just an arm of the government at this point. But yeah, I mean, I am obviously a religious person. I believe in God, our Father in heaven, who's the ruler of everything and the giver of all law. And I believe very strongly that this country, America, is the greatest country in terms of its understanding. I'm talking about the people. The people of this country really understand freedom and God-given rights more than anyone else in the world. And basically, people don't understand that the Constitution that's our protection. The Constitution is our document. It's we the people, that we have this document that says, sure, we'll be part of this government, but here's our contract that says that we're only part of this as long as the government protects us from the following evils. The main part is obviously the separation of powers, to make sure that you can't have just one mono government that rules over you and there's no recourse. And then the Bill of Rights, which are these promises that the government shall not pass laws that will infringe on these God-given rights. And that's our compact. And I view myself as somebody who is trying to enforce that compact and help people in that way.
Well, I'll say it's refreshing for me to have someone like you on our show, because sometimes I think I won't speak for Steve, but I get a little, well, I will actually, because we both get a little black pilly sometimes, and so it's a good reminder that there are people like you out there, and we know a lot of our listeners share very similar core beliefs and values, and it's highly important at this time in our nation because of how far our government has gone, really just against our Constitution, and has forsook those God-given rights.
So let's take it actually to January 6th itself. I mean, we have all our lens of way of looking at it. We have an acquaintance, a friend of ours, who's another FBI whistleblower, who's Kyle Seraphin. And I think he has the most appropriate way of saying that January 6th is the greatest Rorschach test of all time for politics. People sort of look at it and get whatever they want out of it that day. Garrett and I try to be the Joe Friday, just the facts type of people. The way I've sort of summed up that day in total is that you had different groups of people. You had some people who engaged in violent activity, relatively small. Now we're finding out and getting confirmation that there were government informants who were there. There was undercover capacity. There were people who were they are dressing as one side when they really represented another. They were trying to provoke bad behavior. You had groups of people who showed up there expecting a counter protest to become violent. So I think they showed up with body armor, thinking like, I'm going to get involved in a violent action, which you never want to go somewhere expecting that to happen. But after 2020 being locked down and then seeing the cities across America burn, I kind of understand the sentiment of a few guys that were said, I'm going to go give these hippies the beating their daddy never gave them if I get that opportunity. But I think the largest contingent, I think that what we're seeing, the people who are really being dragged through the system are the people that I've compared to Miracle on 34th Street. And if you've seen the movie, it's the people who send the letters to Santa Claus, and then they bring all the letters in to convince the judge that Santa Claus exists. And I think people want their believing. In fact, they did have a First Amendment right in Washington, D.C., which now in the alleged land of the free, I don't know if you do, but the right to speak and assemble and petition your government without redresses for redress of grievances, and then walk through the Capitol thinking, look, we're going to demonstrate 1 million strong, whatever the number is, that we wanted a legitimate audit of the election outcome. And they thought that they had that right to walk through the people's house. And those are the people I think that have really been victimized as the government and the FBI in particular has made the process the punishment. But that's my perspective on things, trying to be as impartial as a lawman as I can. You as a citizen and then as an attorney, really, what's your takeaway from that day? Because you didn't get involved in the defense for a couple of years.
Yeah, so I think that what you said earlier about it being a Rorschach test is really appropriate. And essentially, we have to separate two things. There's January 6th, which was the first breach, which occurred at 12:54 p.m. at First Avenue and Pennsylvania Avenue by the Peace Circle, and then it ended at sometime before 5 p.m. So we're talking about 4 hours of whatever occurred that during that time period. But everybody, the government, basically the violence at the tunnel and all that was ended before 5 o'clock. And then by 5 o'clock, people were just leaving the area. So that's one aspect. And then the other aspect is everything that's happened in the last 4 years since that. So whatever happened on January 6th, I think we could all agree, we have to all agree, objectively, we all agree that Black Lives Matter destroyed this country from the end of May until as late as October of 2020. That was far worse by every metric. Every one of those riots, by the way, was far worse than what occurred on January 6th. So that's one aspect. The legal aspect is the real issue, is the real insurrection, in my opinion, in that the Black Lives Matter, they did not face this kind of investigation and this kind of prosecution. And January 6th are, to this very day, still being arrested. I was at a status hearing. It was an initial hearing of 3 new January defendants yesterday in the DC court. So there are 3 new people. One of them, I know for sure, who's my client, is only charged with misdemeanors. Wow. Now, as FBI agents, you could tell me, do you ever remember hunting down somebody years later for committing a misdemeanor? Did that ever happen? I don't think that's ever happened in history.
In the immediate aftermath.
I want to point out one case. What?
I would say not even in the immediate aftermath. You're told in training at the FBI that we don't have the bandwidth to investigate misdemeanor crimes.
Oftentimes we won't even investigate some felonies unless the threshold is at a certain level, or unless the crime is so egregious where it warrants even getting involved. So that is one of the indicators to me of how weaponized the January 6th debacle has become, is the FBI, and they love to tout it as their biggest investigation of all time. And that should be shameful, and they act as if it's a good thing, and that goes to their hubris, which we talk about often here, and they've totally misread the situation. And like you mentioned with these misdemeanors, that is all it takes for me, especially as a former law enforcement officer, especially as a former FBI agent. You're rounding up people for freaking misdemeanors, and we're supposed to trust you. We're supposed to believe that you have the best interest of everyone in mind, including the quote unquote criminals. But you're going to round up the grandma who was peacefully in line behind a velvet rope because the Capitol Police ushered her through the doors. And I will say there are some people from January 6th who did do bad things, but by and large, the dragnet that the FBI has launched is despicable. It's going to be, I think, in our history, one of the biggest blights on America's eye as anything else.
I have so much to say on this. Just a couple of points. Number one, about people on January 6th who did bad things. Really? I want to see those people. I know that Dominic Pizzola is sitting in jail for 10 years for breaking a window. That's all he's accused of doing. Read his charging document, read everything. I know that Christopher Quaglin has been in jail. He was arrested in April of 2021. He sat in jail pre-trial for almost 3 years, and then he was sentenced to 12 years in jail. And if you read what he did, what he's alleged, this is read in a light least favorable to him. If everything the government says is true, if you disregard all mitigating circumstances, which which could be applied, all he did was shove a couple of cops a couple of times. That's what he did. If that standard was held to Black Lives Matter, there would not be enough room in the jails to hold all of the people. And by the way, there isn't enough room in the jails. That's a whole separate issue right now. But we can talk about that. The other thing I want to say is, in terms of what the FBI is capable of, they just arrested a former NFL player named Leander Antoine Williams. He was on the Detroit Lions. I don't know if you guys hear, or did you hear about this? Look this up. They were able to find him 4 years later because at January 6th, it was very difficult to identify him because it was cold that day. He was wearing like a scarf over his face in the short amount of video that he's even in. It's not even clear that he entered the Capitol. I don't think he did, but they identified him because on his belt he had a distinct red key fob, and they found a public picture that they scraped from all of social media, all of the internet, of him standing somewhere on his belt with the same red distinct key fob. So he was just arrested. That was just a couple of weeks ago. Now, I live in Baltimore, where hundreds and hundreds of unsolved crimes are committed every year. And if you're carjacked, if you're attacked, the police say, "Oh, we're sorry, we can't do it," even though the whole thing's on video. They have the capability of finding somebody 4 years later based on a key fob. Why is it that it's almost like selective investigation that they're able to use, turn on and turn off? It's really scary.
Let's dig into the different ways that the process has made the punishment. We've talked, Garrett and I, about the tactical elements, like sending a SWAT team to go and arrest someone. Where I'm in Daytona Beach, Florida. We were sending a SWAT team to arrest someone who said, "I'll cooperate with you. Just let me know what you need." Confessed to anything that he'd done when he'd been interviewed 18 months earlier, and there had been no contact in the interim time. And that's a recipe for Ruby Ridge, right? And they thought, we're a hammer in search of a nail. This is the most appropriate way to do things. But through the court system itself, and you even alluded to it, that the pre-trial detention, that to me is one of the most overlooked weaponizations that has gone on this entire time, where they keep giving superseding indictments, issuing them so that they can extend the period that the person is held as long as possible, and then continue doing it again and again. And I don't even know if you're aware of this. Every time they issue a superseding indictment, the FBI is claiming an additional arrest stat for that. They're actually benefiting from doing that financially in addition to punishing the person. But how have you seen the pretrial process play out where the person is really just being run through a ringer?
Well, this is where the courts are dead wrong, and I'm going to say that because the DC court has proved itself to be completely wrong. I want to preface with this because as a lawyer, I have to be very careful that I'm not supposed to degrade the public confidence in the courts.
Too late.
But I am allowed to say, I believe, that as a factual matter, the DC court, they upheld this 18 USC 1512 charge, which was on its face just obviously being misapplied against January Sixers. With the exception of Carl Nichols, every single judge and I think it went to as many as 20 judges on the DC district court, they all upheld it and denied any motions to dismiss. And the appellate court sided with the judges, but then it went to the Supreme Court 3.5 years later, and the Supreme Court has effectively struck it down. So all those judges were wrong, every single one of them. So they were wrong about that, and I believe that they are wrong about other things that time will have to tell. The problem is, as you said, the process is the punishment. So I have a client by the name of Ronald Mealy. He was charged with misdemeanors and the 1512. The 1512 carries with it 20 years in prison. Now, he has no criminal record. He's a father. He's a husband. He's gainfully employed. All these things. Not a flight risk. Not a danger to the community. Did not enter the building. Did not engage in any violence. But he was sentenced to 33 months in prison. He had to sit in jail while the Supreme Court is taking its sweet time in figuring out what to do with the 1512. When the 1512 was finally struck down, that was in June, nothing happened to him. He's still in jail serving a 33-month sentence on misdemeanors. So the process itself can be the punishment, because they can charge you and convict you with the 1512 and stick you in prison. And then the Supreme Court says that all the judges were wrong. And it's like, well, whoopsie. Well, sorry about that. But you don't get your time back. You don't get your reputation back. You don't get your money back that you might have spent on lawyers. You don't get the stress, aggravation, the years it takes from your life. That never comes back to you. So the process can crush you by the time you're even found to be innocent. And so that's one very important point. Another point I could mention, if I will, is that another thing that I believe that the district court was completely wrong on is overriding the Bail Reform Act of 1966. That act was to protect us, the American citizens, from pretrial detention. Pretrial detention has to be a last resort. It has to be, because in this country, you are innocent until you are proven guilty. That is our rights as Americans, as God-given rights. And the Bail Reform Act was so that it should limit as much as possible how you could be pretrial detained. And what the DC court did, Judge Beryl Howell, what she did initially, and it's been upheld by all the other judges, is to say that, well, they didn't really mean the Bail Reform Act. January 6th is different because it was an attack on our democracy. So they initially Beryl Howell held a woman by the name of Lisa Eisenhart. This goes back 4 years ago almost. She was a 57-year-old woman, a nurse, 30 years practicing as a nurse, no criminal record. And they locked her up pre-trial because essentially she had, destroyed democracy. So therefore, the Bail Reform Act didn't apply. So they reread the Bail Reform Act to say, well, it doesn't count if it's January 6th.
There's been also discussions about the people, now that the 1512 is supposed to be out and no longer applicable, that if you have been sentenced on that, convicted and sentenced, if you now appeal that decision, that there's going to be potential retribution. The judges are going to say, well, I'll sentence you more harshly for the other things that you're in there for. So we'll wind up you might get more time if you come back at us, which to me is completely antithetical to the Constitution, where you have a right to have a trial by jury. I mean, it's almost tantamount to the talking point about plea bargains being sort of a problem, where you're incentivizing a person to waive their constitutional rights, or you're punishing people for exercising their right to a trial by jury by saying, well, if you go to trial, we're going to really jam you up further on this one. But have you had any clients that have been faced with that decision of, well, do I just not appeal because I don't want to face a retribution from an angry judge who had their decision overturned?
Yeah, well, it's not appealing. It's asking for resentencing. So, for instance, Ron Mealy is a good example. He was charged with the misdemeanors, which it's 2 misdemeanors that could be up to a year, and then 2 misdemeanors which could be up to half a year. So that's a total of 3 years. So he's in jail for 33 months. If he gets resentenced, which he would want anyway, but even if he got resentenced, then the judge could say, well, we're going to give you 36 months because we're going to give you for all your misdemeanors. Richard Barnett, the man who put his feet up on the desk of one of Nancy Pelosi's staffers, he got 54 months on the 1512. Wow. If I'm not mistaken, Judge Cooper said if Judge Cooper didn't say it in this case, I've heard in other cases, I'm going to give you a sentence on the 1512, but for the record, I would give you the same or more on some of the lesser charges also. So Richard Barnett was sent to jail well over a year ago, I guess, and almost, I guess, a year and a half ago, and he got 54 months. The 1512 is struck down, but he's still in jail, and there's nothing that could be done for him. And once again, that's just where the process is the punishment. They so supercharged everybody with so many different things. I mean, just to give an example, there was a man by the name of Ruben Camacho who about a year ago was part of a Hamas-led or Hamas supporter-led siege on the Democratic headquarters in Washington, D.C., which is the same restricted area, and it was protected by Capitol Police, completely under federal jurisdiction. He punched a female police officer in the face. I have the police report. He got 48 hours of community service. He was only charged with a misdemeanor. So why wasn't he charged with? He could have been charged with the 18 U.S.C. 111 charge that can carry up to 20 years in prison. He could have been charged with the 4 misdemeanors, frankly. He could have been charged with all kinds of different things. And he certainly could have been sentenced or a plea deal. I think he got a plea deal. So why was he offered a plea deal of only community service for punching a police officer in the face, a female police officer? That's worse than anything I've ever seen anybody accused of on January 6th. I've seen January 6th people who shoved a police officer. I think punching is way worse. And but that's it. So it's just that, if they choose to punish you with the process, there's no recourse for that.
There really isn't. This discussion of the 1512 charge, and you mentioned earlier the selective prosecution, I think they go hand in hand. And then examples like this Hamas supporter, you talked about BLM earlier. To anyone with even half of a brain, actually less, to anyone who can rub 2 brain cells together, you should be able to see how weaponized, how atrocious this has become. And for those not fully tracking the 1512, it's 18 United States Code 1512, tampering with a witness, victim, or informant. And the Supreme Court specifically ruled on Section C2, which says whoever corruptly otherwise obstructs, influences, or impedes any official proceeding or attempts to do so shall be fined under this title or imprisoned not more than 20 years or both. And I want to just touch on this from an FBI agent perspective for a moment. This is one of those things where somebody got a J6 case and they went looking, and maybe it was an AUSA too. They went looking and found this obscure law and said, aha, we got it. We're going to charge them all with this. And then the DOJ, the FBI, the courts, all these judges that ruled in the circuit and then the district and kept getting appealed all the way up to Supreme Court. And like Jonathan mentioned, took 3.5 years, and SCOTUS finally shut it down because it's a misapplication of the law. That is weaponization at its finest. And that is not supposed to happen in this country. And it makes me think, and Jonathan, Steve mentioned to me before we did the show that you listened to our Holocaust episode. So it was fresh in my mind. Our trip as FBI employees, all of us had to go on to the Holocaust Memorial Museum. And I go to their website often. There's a whole sections on their website about law and justice and the Holocaust. And I just want to read this piece. It says, with a series of key decrees, legislative acts, and case law, the Nazi leadership gradually moved Germany from a democracy to a dictatorship. The role of the legal profession in general and the actions of judges in particular were critical. And I know people say, oh, you jump the shark once you bring this argument into it. And I say, okay, fine. Well, then the FBI has jumped the shark by making all the employees go on that field trip. Because the whole point is to remember human history and to remember how vindictive and evil we can be. And also, the Nazi Germany didn't just jump to concentration camps. No. Those were later. In the early 30s is when this all started, and probably even before then. But a lot of these legislative acts and decrees started in the early 30s. And this is how freedom slips away because of mob rule and mass hysteria, which is being stoked by the media, which is being stoked by judges and law enforcement officers who have been completely captured politically. And instead of upholding the rule of law, they say, how can I get my enemy? And that is not supposed to happen in this country.
Can
Yeah,
you
and
go ahead?
no, and I'll add to that just the idea that the way that it's stopped is when a few good people will stand in its way and speak out against it, and that's why I really appreciate your show.
Can you put us in the courtroom when you've had an opportunity to go to trial, and the complications that you've had to? I know there's some craziness about the jury selection that goes on there, but before that, from my standpoint, I've been to trial 8 times, which is very unusual for an FBI agent to even go to trial. It's 97+% of federal cases are pled out. But I've sat in the witness chair and been under cross-examination, and it's not a pleasant experience, but it is what it is, right? You just follow the process, and that's the defense attorney's job. Have you had a hard time nailing down or even doing any sort of cross-examination of FBI agents? Because what my interpretation was is they so compartmentalized these cases so that they couldn't answer any question from a defense attorney, which is wholly inappropriate.
I'll tell you a couple of things about cross-examination. I do not have a hard time with it. Problem is that the juries and the judges don't care. The verdict is already determined in advance. So, I mean, just to give you one very good example is that they bring to almost every case a deputy detective who's, a Capitol Police high-ranking official who was there on January 6th, named Thomas Lloyd. I'm going to give my opinion right now that I think that there might be something mentally deficient with this individual because that's my opinion. I mean, I'm not a doctor. I don't know what to say, but I mean, I welcome anybody to, draw their own opinion by coming to a January 6th trial and viewing him on the stand. He's testifies in almost every case. Thomas Lloyd, I could show the jury 1,000 times that Thomas Lloyd came out of the Senate chamber at 12:54, right when he heard on his radio that that there was a breach at 12:54. So he came out within minutes of that, and he stood on the Upper West Terrace, and he just watched as this massive crowd, unprecedented according to them, never before ever seen in the Capitol history, and he's been there a long time, just formed on the lawn. And he was right next to officers from an elevated position who were shooting rubber bullets, and he was watching on the lower terrace as they were shooting smoke grenades. 2 people died between 1 and 1:30. Kevin Greason and Ben Phillips both had heart attacks from the smoke grenades, allegedly, probably between 1 and 1:30. So there's ambulance, there's already fatalities or at least severe injuries. Matthew Joshua Black was shot in the face. Supposedly at 1:15, there are all these allegations that he could clearly see of officers being assaulted and things that's their allegations and all these things going on. And it's mayhem in World War II. So you would think that he would go back inside and say to everyone, emergency, everyone, it's 1 o'clock. I know we have important business here, but we need everybody to evacuate. He did not do that. He did not do that at 1 o'clock. He did not do that at 2 o'clock. It was only after 2 o'clock, about 2:15, that he went inside, and he didn't evacuate them until even later than that people were already in the building, and doors were broken, according to them, and windows were smashed. So where's his liability and culpability in all of this that he didn't, Ashley Babbitt would still be alive today, in my opinion, if Thomas Lloyd had gone in earlier and evacuated everybody. That place is so fortified. They did hold everyone. Nobody even tried to surge for an hour and a half. So he could have brought everybody through the tunnels when it was safe, and Ashley Babbitt would still be alive because they claim that she was shot because there were still lawmakers in the back at 2:44. At 2:44, almost 2 hours later. So I bring this all up to say that you could show all of that while this guy, their star witness, gets on the stand. And if this was a regular police case, and you showed how negligent the police were, in my opinion, that they didn't evacuate everything, then, the jury, you would think, or the judge would be swayed a little bit by that, but obviously they're not. So cross-examination, I know the facts of the day pretty well. I can cross-examine them, and that goes for the FBI agents as well. It just doesn't sway the jury. If you want, I can tell some stories about cross-examining FBI agents and showing, in 2 instances, I showed how they were dishonest on the stand. And, if you want to hear those stories, I mean, I have a lot of stories.
By all means, we would love
Unfortunately.
you to dunk on our
Yeah.
ex-girlfriend
And
at the FBI.
feel
who
free to
took-
name the names of the agents too.
They
I'm not going
purport
to
to
name names,
represent
even though they're all public record because they testified at trial.
fidelity,
But,
bravery, integrity is not a thing. So they deserve it, and they should be named and ostracized.
Well, and they've embarrassed themselves, in my opinion, because it's all on public record right now, and they know what they did. I say to my clients, I'm a religious person, obviously, and so are all of my clients. I haven't met one January 6th who is not a deeply God-fearing person. And I say to them, this is not your trial. This is the trial of all these people. They are on trial before God, and we're going to see if they do the right thing or the wrong thing. And they know they don't do the right thing. I've never had a juror look me in the eye during the verdict. And I'll tell you something else. There's a local rule in DC that they're probably going to change because of me, that the rule says that if after the verdict, but before the jury is dismissed, if the lawyer asks for permission from the judge to speak to the jury, then the judge shall allow it. The judge has to allow it, but the judge can instruct the jury that they don't need to answer any questions that I ask. So just at a recent trial, I invoked the rule, and the judge said to the jury, you could stay. And the judge and the prosecutor said, we're going to go back with you to talk to them. We're not going to let you do that alone. And I said, that's fine with me. I said, I just want to ask them, I'm a J6 attorney. Can you tell me what I did wrong, what I could do better next time, and give me some constructive criticism? So the judge said, okay. And he instructed them privately in the jury room. And then he came back and he said, they all left except for one. One guy stuck around, and he gave me some good insights that I'm not going to share. But anyway, so the jurors, they know what they're doing. They have made up their minds, the minute they learn that this is a January 6th case. And obviously the prosecution knows what they're doing. So, so stories about FBI agents is what I was going to say is, I had a grandma case, a woman named Cindy Young, walked through the velvet ropes, all that business, no violence, no vandalism, nothing, just charged with misdemeanors. And she had a trial. And the first thing that gets us is that the FBI agents, 2 agents from a small field office in New England, they were there the entire trial. They have nothing else to do. There's nothing else going on. And I know that some of these agents are reassigned from sex trafficking and from drug cartels and organized crime. So for 1 full week, they'll sit. This has happened to me on numerous occasions. 1, sometimes 2 weeks, the FBI agent with nothing else to do from some random state, small fields offices with maybe only a few agents. That's no problem. We could take the week off. This is more important than anything else you're doing there. There's no need to have them there at the trials, but apparently the government wants them there. In this case, there were 2 FBI agents. And the reason was, and I brought this out on the stand, is that Cindy was interviewed in January of 2021, days after the event, by the FBI agent. The FBI agent said to her, because at the time, I don't think the memo went out that this was worse than the Holocaust. So the FBI agent says to her, yeah, don't worry about it. Like, we're not going after you. And then the FBI agent was contacted by Washington a few months later, like in April, and they said, we noticed that you interviewed Cindy Young. Did you open a case? And he said, no, we're not opening a case. And he wrote that in an email, and he forgot about that. So he testified that he started an investigation right away. And when I cross-examined him, I had to show him his email to refresh his recollection of what actually occurred. And he closed the case because imagine if it was a Black Lives Matter case and they were interviewing somebody about, something like they weren't going after every misdemeanor in Black Lives Matter. So then a new FBI agent, kind of a rookie, he was assigned the case. And this guy wrote something like, I mean, it was like 17, 18 reports. And he was so intensely investigating this case in a very short amount of time. It was bizarre how much time he spent. And I had a big stack of his reports that I got to show him to refresh his recollection. And after he testified on direct, I refreshed his recollection that he had concluded that she was peaceful. That's what he wrote in his conclusion in his report. It's not, he did not testify to that until I refreshed his recollection, and then he had to. Now, mind you, she's charged with civil disorder, which means that not only was she trespassing, not civil disorder, with disorderly conduct. So not only was she trespassing, but she was not acting peacefully. His report said that she was acting peacefully. I showed that to the jury. I showed that, not only did I show it to the jury, I showed the jury that he had omitted that or even misrepresented that on his direct examination. The jury didn't care. It does, cross-examination doesn't mean anything. We do it only to preserve the record for historical purposes, but we know that it's not going to have an impact.
This shows the departure that the FBI had from its rules for managing cases. This is basically one of the elements that I blew the whistle on, the fact that the autonomy that the agents have to investigate their own cases is gone at this point. They're getting directives from Washington, D.C., which if Washington, D.C. wants to investigate the case, they can, and they can cut leads to the field and give them directives to conduct interviews or do anything that's necessary for an investigation, because it makes no sense to fly someone from D.C. to Oregon to go conduct an interview. But they're putting the names of those agents on those cases, and they have no control over them at all. And that should be something that's turned over to you as a defense attorney. You should have the opportunity to say to that agent, well, agent, I see you're the case manager on this. Did you do anything that was investigative on your own, or did you get directives entirely from someone else? And why don't you have that sort of autonomy? And again, it's a fait accompli with the jury pools in DC. It doesn't matter. But as far as preserving that record, I think it's really important to show how the FBI did that. And I also would love to see a defense attorney go up and present the argument that your boss got a bonus because you opened the right number of domestic terrorism cases. I think that that's probably pretty relevant to a defense.
Well, you would think. You would think. Unfortunately, what's allowed to ask and what's not allowed to ask is determined in advance by the judges.
Jeez.
So, and they have a boilerplate. The prosecution has a boilerplate motion in limine. A motion in limine is a letter that you write to the court prior to the trial that says to ask the judge to not allow the other side to present the following as evidence because it's not relevant or it doesn't apply or whatever. And it's called the omnibus motion limine, that they basically just cookie cutter boilerplate file it in every case, and it's always granted. I'll still write an opposition to it, but some people say, why didn't you ask this? Why didn't you ask that? It doesn't work like that. And it's a shame. I think that we should be allowed to ask these kinds of questions.
Absolutely, you should be, especially in a criminal defense scenario. That's absolutely ridiculous to me. And I already have been leaning towards blanket pardons for J6ers, and hearing that, or actually just our whole conversation so far, it's only making that more firm, that belief more firm, is just because of how egregious the government has behaved in persecuting these cases. All of them just need to be dismissed. And
That's it. And I want to appeal to, I'm sure that these people don't watch your show, but all of the people who are like, well, I didn't break the law and they shouldn't have been there, and they're lawbreakers. Just understand that this is the canary in the coal mine.
yes,
That the reason that, for instance, we allow a criminal who we know is guilty to go, he's guilty. We know he's guilty, but we will allow him to go free if the government has, let's say, withheld evidence from him prior to the trial, or if the government got evidence. They found the gun without a warrant. So they come to court and they say, look, we have the gun. It's smoking. We know he did it. You send that man home, because the government has to follow the rules. If we allow the government not to follow the rules against that guy, they will not follow the rules against you. So you are correct. All January 6ers have to go free because of the government abuse of power. And also because of the venue. The venue was unfair. Everyone knew they could not get a fair jury trial. So anyone who pled or anyone who went to a bench trial where you asked the judge to decide did so because they knew that they could not get a fair jury trial. And there are many reasons, many ways that we can prove that DC was not an appropriate jury pool. One way, I'll just tell you right away, is that there weren't enough jurors there. One of my cases on the stand, one of the standard questions that you get to ask the jurors beforehand is, have you ever served on a case before? And a lady volunteered that, yes, I have. Now, normally the judge says, you don't have to tell us the particulars of that case, but she said, no, I'll tell you. It was a January 6th case. So she had served. I was the distinction to be the lawyer at that case where we had a double juror because she volunteered it. She didn't have to. Wow. So what we now know is that at least one juror was there twice. And we know that she convicted because everyone's been convicted. And by the way, she made it onto the jury. So people say, why didn't you strike her? I tried to. You can do two ways to strike a person. You can tell the judge, this person should be stricken for cause. The judge said, no, I don't see why she can't be a fair and impartial juror. It's a different case. So then say, well, now I have my preemptory strikes. I get 3 strikes or so that I can, knock people out. She wasn't the worst one. On that same jury, I had one lady who I was allowed to ask her about like her social group. So I said, let me ask you a question. Hypothetically, you run these meetup social groups. She says, yes. I said, okay, let's say 2 people apply. There's only 1 spot. One person's wearing a MAGA hat and the other one's not. And you don't know anything else about these 2 people. Will that affect your decision? She goes, oh, well, nobody with a MAGA hat would want to hang out in my groups because they're for queer people of color. And I'm like, so you're saying that people with MAGA hats like immediately won't like queer people of color? The judge's like, that's irrelevant. You move on. I'm like, what are you talking about? I'm just mirroring back what she said. He said, she answered your question. Would you have any other questions? I'm like, no, I don't think so. Then the judge says, can you be fair and impartial in this case? And she's like, yeah, I think so. So she was allowed. I had to strike her. She told me that if she knew somebody who supported President Trump, she wouldn't even hang out with them socially. So I can't. And the other examples that I can give, lots and lots of examples of where people say crazy things about en voir dire, which is when you kind of interview the jurors to see if they're appropriate. And then the judge asks the final question. Well, given that you said all this stuff, you hate Trump supporters, you hate Trump, you think they should all be, do you think you could be fair and impartial? And they say yes. So then the judge allows them to be on the jury. Now, one time, this is funny, this happened to me in a trial. The last question is, do you think you could be fair and impartial? And most people just say yes. So one guy said, no, I don't think so. I really don't like people who support President Trump or whatever. So then, so the guy left and the judge says, I guess, Mr. Gross, you'll strike for cause. I say, no. And the judge's like, you'll have to explain yourself. I said, he's the only honest guy. he said, he answered the question truthfully. I want him on the jury.
And this is the exact opposite of every jury experience I've had, where people will say the worst things. They don't care about their reputation because they want to get off the jury. I mean, I've had domestic violence cases where a guy said, I think the woman deserves it, just so he didn't have to sit through the trial. I mean, reputation be damned, but it seems like it's the exact opposite there in DC. How about from an evidentiary standpoint? What sort of improper evidence are you seeing presented that is just irrelevant to the case? It's just sort of like waving a red MAGA flag in front of a bull.
I could show you pictures that, it's exactly right. So, just what comes to mind, Richard Barnett, one of the exhibits that the government put into evidence was a picture that he had. I mean, I asked him about it. It was a picture of a pickup truck with a flag on the back of its tail that said Trump 2020 or something like that. And I said, Richard, is that your truck even? This is Richard Barnett. And he said, no, that must have been like on Facebook. It just came in my feed. So I hit, like. That's literally all it was. It was somebody else's truck somewhere else, but it said Trump on it. And why is that relevant? It's not. It's there just to inflame the passion of the juries, because 93% of Washington, D.C. votes Democrat in both the Biden election and the 2020 and the 2024 election. So, so obviously we know how people who don't like Trump feel about Trump. So that's it. It's just to inflame the passions of the jury. Also, same thing. I have grandma cases where there'll be a picture from them from like another rally months earlier, holding a flag that says Trump or holding an American flag, and that's but they're at a rally for against COVID, or they're at a rally, also protesting the election. So, or they're just waving a flag that says Trump. That's enough that people who are on the other side of the political divide will say, well, they're guilty.
So we're in the final 5 weeks here of the Biden administration. There's going to be a new incoming Trump administration. He's made pledges that he's going to start looking at pardons. I was looking at the comment he made in Time Magazine about the 9 minutes. He said it'll be a day one, maybe 9 minutes in, and I kind of started thinking, well, it could be bluster, or it could be the exact spot in his inaugural speech where he just says full blanket pardon. I think we're all sort of on record. We need to pardon everyone, but at the same time, what do you think? If you're going to project out, is going to be the way that this eventually unrolls?
Well, I don't like to make predictions, especially about the future. I think that's what Yogi Berra said. But so I'm not going to try and predict. I will tell you what I think should happen. Three things have to happen. First of all the people have to be, let's say, freed immediately. Now, that could mean a pardon, but not everybody wants a pardon, frankly, and not everybody can get a pardon. People who are still pending, they, you don't need to pardon them. You could just drop the cases, just dismiss the cases against them. But you have to do something where everyone goes free immediately. Immediately. I mean, I'll mention some people who are in jail. I mean, I could go on and on, but I mean, Jake Lang still has not had trial. Benjamin Berlew, my client, he's a American hero, war hero, who's in jail right now. I can go on and on of people who are in jail right now. Everybody needs to go home immediately. And that's not, by the way, that's not even the pardoning. That's not even the DOJ. That's the Bureau of Prisons. You need to send everybody out of jail immediately. You need to suspend all cases so there are no more cases immediately. We discuss later whether they should all get pardons, whether they should get exonerated, or some other way to figure it out. That's one. Number two, compensation. There has to be some act towards compensation for these people. Some of them can never be made whole for what's happened, but everybody should be compensated in some way, and that needs to be figured out starting on day one. And then number three is we have to make sure that this never happens again. There must be an investigation into the investigators, and that includes three people at least. We need to investigate the DOJ. We need to investigate the BOP, the Bureau of Prisons, and we need to investigate the FBI. All of those need to be investigated to understand how this happened, who gave the orders, who gave the order last Thursday for a blind grandmother who just had eye surgery on her retinas to be picked up by an FBI agent who had to spend 15 hours with her in one day. And he is from, she was told by the FBI agent that he's from a child sex trafficking unit. Who gave the order that that person who should be looking for 500,000 missing children should pick up this blind grandmother at her rural farm in Missouri and drive her to court? Who gave that order? We need to know that. So those are the main three things that need to be done. I would also like to see legislation that does some measure to repair the system a little bit so that the process can't hurt people enough. We need more strength on the Bail Reform Act that could counter the case law that they've now made for being able to lock people up pre-trial. We need to make sure that never happens again. We need legislation to counteract the DOJ's ability to, charge you with some outrageous crime. There has to be a consequence on the other end so that there's a little bit of risk on not just the agency, but on the individual who signs their name. That if you charge somebody and then 3 years later, then you know what it is in the Bible? You need to do to them what they intended to do to their person. So if you wanted to lock them up for 20 years with the 1512, and then the 1512 is struck down, you're going to face the same process that you subjected that person to, or something of that nature, where the DOJ will be scared to prosecute people under these flimsy things, where the FBI will be scared, where the U.S. Marshals will be scared if they lock somebody up based on this, where the BOP will be scared if they lock somebody up on this. The agencies need to be scared. And then the other thing is that we need a little bit more assurances that can be done legislatively to prevent radical judges from being wrong. Some of the judges have said outrageous things on the record. I'll just give you one example that, by the way, should have been the end of a trial. I mentioned Deputy Chief Lloyd. I was at a trial where it was a bench trial, and he testified, and then he's about to leave the stand. And then the judge says to him, on the record, this is in the transcript, "Thank you for your service in general and particularly on January 6th.
Wow.
So that judge is the decision maker in the case. And he just came out and explained that he feels grateful to the star witness to prosecute this person. You know who makes the decision whether that judge should be recused or not? That judge. So there needs to be legislation to protect us from a judge who might not be able to see their own bias. The DC judges can see the Capitol from their offices, from the windows of their offices. They possibly view themselves as victims. So maybe they should have recused themselves, but they cannot see their own implicit bias. So we need all kinds of legislation to protect us from that as well.
And how far would you extend it? I mean, you're talking about the largest investigation that the FBI has ever done. Does it go down to the brick agent who went and did that arrest? I mean, like I'm for it. In fact, maybe let's think outside the box. With an incoming new director or new president, maybe we keep January 6 cases open and then tell them not to make any progress on it. And then when they don't make progress on it, we can say that your performance is bad, so we can fire you for that. That would be a creative way of doing it. But I mean, how far would you, as a person who's seen the malevolence go on? I mean, you're talking about an agency from the FBI, 14,000 agents. I don't think anyone's hands are clean at this point. Did we just freeze up in the final minute here?
I think so. Hopefully he'll come back.
Hopefully he'll pop back in. Nope, I think we lost him. He's coming back. We want to definitely make sure we close it out because of the time here. We want to be respectful of Jonathan's time. I pose it to you, Jonathan. I mean, I don't think anyone's hands are clean from an FBI standpoint. Do you want to see 14,000 guys walked out and put in prison?
Not put in prison. I'm against that, and I would defend them if, at some level, if they were put in prison themselves. I just want there to be accountability so this never happens again. There has to be consequences. And there has to be accountability. The American people need to know what happened, and also reputationally for all the people who were harmed by this. You know, you look on Twitter, there are all the haters who are out there. Maybe they're bots, but maybe they're real people. I've met some of them. You know, they think that it was justified what happened here. That something needs to be done to make sure that the American people know what really happened. With the real crime of January 6th was not what happened on that day. It's what happened since.
That's well said. You know, we're closing it out here. I want to make sure that people can find you. You're on X and social media. Can you plug your handle, and then also anything else that you want to promote to our audience here? The American Radicals podcast audience is very supportive of what you got going on.
That's great. Yeah, no, you can just find me on Twitter at JON_GROSS. It's right there. That's I post only about January 6th, and follow me, but also find all the people that I'm following and follow them. So, you know, I just want to plug two people, Jaleese and Mark Middleton. who just went to jail yesterday. I don't want them to be forgotten about. I don't want any of the people who are in jail to be forgotten about. So follow all those people who you can find, and so your support means a lot to people, because when they find out in jail from people who call or whatever, or that people are thinking about them, it gives them hope.
Well, that's great. And we really appreciate your time today on this. It's been really enlightening. I know we've been in the weeds on this ourselves, but at the same time, getting your perspective, I know I really appreciate it. So we'd love to have you back maybe in the future on a brighter time when you can tell us about how all of them have walked free and now they're being compensated for their pain and suffering. So we can all pray for something like that. So thank you again, Jonathan. And we want to make sure that we send everyone off today. Appreciate you joining us here on the American Radicals podcast. We'll be back with you Thursday. Again, we're doing the retrospective on Saturday. That will be looking back at the final news stories that were from the middle 4 months of the year, the bombshells or the flashbangs. So it'll be fun. Make sure you join us here on Rumble, rumble.com/amradpod, as always at 10:30 Eastern time. And until then, have a great day.
You've been listening to the voice of the Suspendables on the American Radicals podcast. Follow us on rumble.com/amradpod.